Hello, everybody, and welcome to this Supreme Court case overview. In this video, we'll be covering Brown versus Board of Education, probably the most famous Supreme Court case of all time, when the Supreme Court really looked at that test of segregation, sorting people. When we put people into different groups legally, even if those groups are equal, is there harm done? Does that violate the 14th Amendment, the guarantee of equal protection? This is, again, if you've heard of any Supreme Court case, you've probably heard of this one, and we're going to try to unpack it and make sure you understand the legal ramifications, how it could apply to other cases, and so that you can be really prepared for this one on the AP test. So let's dive right in. Brown versus Board of Education, a lot of people actually misunderstand the crux of the case, or why the case was chosen. And hopefully in your textbook chapter about civil rights, you can get some more of the background here. Everybody knows that the schools in Topeka, Kansas, as well as elsewhere, actually most of the American South were segregated. We have schools for white folks and schools for black folks. But why Topeka, Kansas? Why Linda Brown? Why this school in this case? Well, the NAACP chose this case because they thought there was a significant fact that they could use to their advantage. And it was this: the white schools and the black schools were about the same. Most people assumed that the issue was that, well, the white schools are way better than the black schools. No. The reason why this was chosen, because one school or one group of schools in Topeka, Kansas was not better than the others. They had the Circuit Court of Appeals they affirmed the lower court's findings that the curriculum was about the same, the qualifications of the teachers was about the same, the materials such as textbooks was about the same. And so the question was purely of that doctrine that the Supreme Court had formulated in the Plessy versus Ferguson case: separate but equal. Is separate but equal okay? And this, the NAACP thought, was the best test case to bring, along with a few others they used to support their case. This is the one we remember of: can we get separate but equal and segregation overturned? And Thurgood Marshall, the lawyer for this case and for Miss Linda Brown, would later go on to become the first African-American Supreme Court justice. But I'm already getting ahead of myself. The case really dealt with the particular case of Miss Linda Brown. You see, Linda Brown was not allowed to attend the school that was closest to where she lived. Off the top of my head, I believe it was 6 blocks away from her house. Instead, she had to walk 6 or 7 blocks just to get to the bus stop to go to the school for the African-American kids. But this was entirely because of her race, and her parents tried to get her into the other school. No dice. She was without the ability to do that. And the Supreme Court, in a 9-0 unanimous ruling, said that this school segregation was unconstitutional because the 14th Amendment's Equal Protection Clause protects citizens from segregation. They said, yes, we have called this separate but equal. However, we are now going to acknowledge that separate is inherently, automatically, just by virtue of it existing, separate is inherently unequal. And this case could not be more significant as far as Supreme Court case rulings go. It completely ended segregation in public schools. As you see, that wasn't overnight, but the ruling was clear. There were no circumstances under which segregation in public schools could be considered justified. Now, why the switch? Why go from the fact that the Supreme Court, 60, 70 years before, had affirmed segregation, to now saying that segregation that's separate but equal is automatically unequal? Well, one of the big advantages in this case for the Linda Brown side of the case actually turned out to be emerging science and the emerging scientific consensus that perhaps this whole racism thing was totally invalid. In the Supreme Court ruling, they cited a study that is today often called the Doll Study. And this Doll Study was done in 1947 by a couple of psychologists. They had young African-American children. They gave them the opportunity to play with a white doll and a black doll. And in most cases, not only did the young children choose the white doll. They actually, as you can see from this quote from the paper, they rejected the colored doll. They already had this negative association with their own race. And the Supreme Court, in a very short ruling, said that this clarified that the impacts of segregation on young children were incredibly damaging to the development of these young people. And so it's a historic Supreme Court ruling, and it's the mixture of science and history and politics. And you're going to want to understand why they would overturn that ruling of that separate but equal is okay. Now they're saying no, separate but equal has damaging effects on our country's youth. But 1 year later, Linda Brown would find herself back at the Supreme Court. Desegregation had not happened. And so in a case that we call Brown versus Board of Education 2, 1 year later, the Supreme Court reheard the case, and they said not only does desegregation have to happen, but that desegregation must happen with all deliberate speed. Now, you might read in your textbook, you might hear people talk about this as if it was a win at the Supreme Court. However, many civil rights activists saw it otherwise. What they were dealing with is something we have talked about in this class before. It's that the Supreme Court has no way to actually enforce their rulings. And so it was a long, hard battle after this, right? This is in the early 50s. We know that it'll be 10 years after this that Martin Luther King Jr. is giving his I Have a Dream speech, right? And so the point is, yes, this was a historic ruling. It was an important ruling, but because of how our government is set up, because the Supreme Court does not have the power to enforce their own rulings, well, the battle for civil rights in many ways was just beginning. Now, what would you be expected to do with Brown versus Board of Education on the AP test? How would you be asked to maybe apply this case? Well, one of the questions that they've asked before since this new test format with Supreme Court case-based FRQs was a Brown versus Board of Education case. And they asked you to use this equal protection clause to explain how it couldn't just apply to Brown versus Board of Education, but could apply to other civil rights struggles as well. You'll want to know that equal protection clause in the 14th Amendment. But also, the Supreme Court has wrestled with the ruling of Brown versus Board in that it said that segregated schools, that giving different people different access to education had potential legal issues. And Brown versus Board of Education has been mentioned more than any other case in the battle over affirmative action. If we now say we want to give an advantage in admissions to, say, African-American students to colleges, well, many people have said this violates the same principle of neutrality and equality in Brown versus Board. And the question remains, did this ruling just mean you cannot use someone's race against them? Or did it mean you cannot consider someone's race at all? And there's a contrast there between segregation and affirmative action that in our courts today still remains thoroughly unresolved. Thank you for tuning in today. I hope this video was helpful to you. I wish you the best of luck. Have a good one.